So remember, we have about 1.5 hours to go, and we're still waiting for that session at the Supreme Court to begin officially. But before then, I want us to have a conversation here in studio. Good afternoon.
Afternoon, how are you?
I'm fine, thank you.
Thanks.
All right, joining me is Ben Kithi. He's a lawyer.
George Kithi.
George Kithi, sorry.
Yes, thank you.
Yeah, and he's going to be breaking it down for us on really what to expect. Thank you very much for joining us, George.
My pleasure.
All right, so what is at stake at the Supreme Court this afternoon?
Well, the Supreme Court has pronounced itself on the decision as to the petition that was filed against the 26th August, 26th October election of President Uhuru Kenyatta and the declaration, and sustained the declaration. Consequent to which President Uhuru Kenyatta was sworn in as for his second term as president. It then, as pursuant to law, it had 21 days. That's determining today to pronounce itself on the reasons, because that was a determination without the reasons. Now, I think the legal issues that will be emerging will be related. Basically, we should be looking at a Supreme Court that is in jurisprudence transition, meaning that there is the law that is being developed over time. I do think the 2013 Raila Odinga decision informs the conduct of the case, both on 8th of August election and also this decision today.
All right.
Reason for that is the pronouncements have continued to be quoted and have become issues for discussion before the court and determination until today.
All right.
But the emerging issue would be probably the standard that need to be adopted by court. Standard being that what is the extent to which a court will accept that mistakes have happened but still have not interfered with the declaration of a presidential candidate, and when does it do so? The issue I do know that came out on in relation to the 8th of August election was the issue of the forms versus the right of the voter.
Yeah.
That's an issue that emerged as an issue for discussion and controversy in the last nullification, and therefore I think that may be settled and a chance to settle it now. Other issues that will be emerging certainly will be who then brings a petition. We do know that the Constitution prescribes so much latitude and liberty for anyone to bring a petition. But you do understand that the difference between this decision that's going to be read now, the reasons going to be given now, and the other one for 8th of August, is that Raila Odinga, as a very important party in the 8th August election, he himself was a petitioner.
Yes.
In this one, it was people not participating as candidates, although they are voters. So to what extent does the what is the delineation of latitude in the context?
All right.
So those would be the emerging issues we'll be looking at, yes.
All right, so we'll be getting deeper into particular issues, but also, you know, critics and legal minds are also saying that it's going to be a time also to reflect, really, maybe if we need a longer period when it comes to looking at this, at the petitions. Remember that we only had 60 days to bring, you know, the country again to an election. So do you think also, just looking at the technicalities, that we'll be able to also get more information from the Supreme Court with regard to that?
Yes, you're right. In fact, I dare say that it's professional harassment to the lawyers and to the judges to constrain them into latitude within which, into a confinement of a period such as 14 days within which to do everything.
Yeah.
Remember that land cases do take much more time, yet the public interest in them and the importance is lesser because it then litigates and delves into private issues as opposed to a public issue. I do think, and certainly so, that if there is an expansion of the period within which the petitioners can file their cases, the cases are heard, and determination within which that is done, I think that will do more justice by allowing more time within which research can be done, legal arguments can be made, and then the endowment of law towards building it up to wider aspects of justice would also be done.
All right.
Point is, I think I've had this several times and times without number from the mouth of Justice Maraga, the Chief Justice himself. and President of the Supreme Court, when he complains about time, and he keeps on saying members of parliament must look into the timelines because it is not enough and human possible. And he's used that word, even human possible, to deliver reasons and also to delve into the truckloads of paperwork that's come before them. Remember that a single document may be more talking than 1 million documents out there. So then if you have 1 million documents, that truckload in itself, you must discover from every paper the content of each information for you to be able then to discern.
And you have to go to scrutinize.
Yes. You see, one paper may be, which you may not even see out of the 1 million truckloads of paper. So you may not see that document, yet it could be the one that tilts everything. The game changer for everything. So you may end up giving a verdict on one side because of the human impossibility. And remember, we're dealing with human beings, not angels. They must get tired. They must constrain themselves to lifetime, to some timelines. And therefore, I do think the proposed reforms by the court in the way it complains about the time still needs to be looked at. And also, maybe it is a good time also for the court to prescribe the type of reforms that would inform the path towards a better environment within which a determination will be made and a platform upon which then parties will have more liberties to engage before court.
And there's something that they're thinking about, yeah?
It's something that has actually been proposed. Was actually proposed in the Raila Odinga 2013 case. I think there was an attempt. In fact, a committee was formed, that of Kaito Murungi, and I believe Senior Counsel James Orengo. I think there was an attempt to do that, but of course of political differences from both sides, it never saw the light of the day. We found ourselves in the same problem again. We think that something better needs to be done, and we all accept there's something wrong with the timelines and some aspects of the Constitution that needs to be looked at as well. All
right, let's now go to the nitty-gritties of, what the explanation that we are waiting for. One of the biggest issues really was actually coming from the Constitution itself. First of all, on one hand, the Constitution says that an election must be conducted in 290 constituencies. And on the other hand, it says that every Kenyan should have a right to vote. Yet IEBC went ahead and announced the winner without all these constituencies. So what kind of direction really are we looking at, considering that this is an opportunity to build jurisprudence for the future?
That's an interesting and emerging point. The Constitution has not been tested in that respect. Remember that every single provision and article and text and line in the Constitution is still very important. It prescribes a right, it prescribes a duty, it prescribes an obligation. So then the obligation for IEBC is delineated. It is prescribed on how the election should be conducted. In fact, there's a lot of detail in the Constitution as to how an election should be conducted. So then parties are supposed to exploit the Constitution in the manner that we saw. For instance, the opposition can exploit it by not going for an election, but still say that we're going to have an election in these certain constituencies, and in fact refuse and tell their people and incite their people not to participate, because that then derogates on a provision of the Constitution, therefore possibly renders the whole election null and void. That was the intention. However, the Constitution also presupposes what an election ought to be. It has been said, of course, in previous texts of judgments, that an election is a process. So the mere fact that probably we've laid out a meal for people to come and eat and they don't eat does not mean that we haven't served. So then what it means is that have we provided or possibly tried to provide the environment within which an election should be conducted? That's what we'll be investigating, whether it's an issue they've dealt with. The other issue is this.
But how can they prove, how is it proven, in a court that, the environment was
the discourse before court, the discourse, for instance, before court was an allegation that elections were not conducted before every constituency, which is true. However, the response was, and that's the reaction from IEBC and, of course, those opposing to that argument, that the election was, the materials were brought, but people refused to participate. For instance, the question that then will be emerging, fast forward to that, will be, do we have a right to refuse to participate in an election just like you have a right to vote? Number two, is there a right called a right not to vote? And therefore, is that deniable can a right not to vote denied, or can you enforce a right not to vote? Like, for instance, can I say, don't pass here because I don't want to vote? Is that enforcing your own right?
Okay.
And therefore, that probably is the environment which the court will discuss in its judgment to see how it packages it. But most importantly, also remember that notwithstanding that some constituencies have not voted,
yes,
in fact, the repeat election was not repeated in certain areas, yet IBC had said it's going to repeat. Remember, IBC never cancelled an election in certain areas. They promised to repeat, but they didn't repeat. However, what happens is, once you've consolidated, collected, and added up all the results from the entire country, then you compare that with the remainder of the areas that have not voted. Then you calculate the maximum that will have been gained, whether then it is going to upset what has already been done. So if the work that has already been done cannot be upset, for instance, by addition or subtraction of the votes, that would be added if an election was conducted, it means, therefore, and as constitutional provided, you don't have to conduct that election and can proceed to make the pronouncement. I believe that's an issue also that then is going to be discussed.
Interesting, because the same constitution says that everybody should have a right to vote. But also just going now back to the numbers, you have 1.7 million people who did not participate, in this repeat poll. What should the judges do so that they do not balkanize the country when delivering this speech, when delivering this explanation, such that the people who did not vote do not feel like the Supreme Court is actually stamping its authority on why they did not vote?
Ordinarily, a judge is supposed to be a very lazy person. In fact, he's supposed to be one of the laziest professions available. You see, a judge does not go to the streets and look for cases to come and administer them. A judge is supposed to sit in a laid-back couch, sip some coffee and wait. So then when people knock and give their cases, then he springs into life and starts making that determination. So you see, when people come before the judge and they make the arguments as they did, the judge is confined, has very little liberty upon which he can do anything except look at the Constitution and look at the law. That's the path, the narrow path within which a judge is supposed to walk. So then the confinement of the Constitution and the law forms the cocktail of the liberty of the judge which should make to make a determination of a case. Suffice it to say, therefore, that notwithstanding how the decision will resonate with supporters or non-supporters of anything, a judge must be beholden to the rule of law within the confines of the Constitution and the law and the statutory provisions. So once
what about the practical environment in which we're in?
The judge has some liberties, like a principle called taking judicial notice of something. Day and night must happen. So you can't, therefore, even if it's unwritten in law, that must be there and that must be night, and so on and so forth. So that those practical situations that a judge will put into consideration without necessarily being an issue that is argumentative and that can invite issues that will discause, for instance, an aggression from either side. So that practical environment is very important, but must not interfere with the constitutional provisions and the law. So what the judge will be beholden to, he has to be as organic as possible, so that he doesn't give a decision that is that will create a vacuum of sorts. He must answer to the questions within the confines of the settled environment, because a judgment must then transform into elevating a social order in society, ultimately complementing social order as it exists in the society, meaning the environment that exists. But eventually, yes, the Supreme will be the Constitution and the law as is provided in the context.
In the context. All right. Thank you very much, Judge, for your insights on this. Well, we'll be looking at that bigger explanation. But just a very brief comment from you. What do you think ignites this whole process with the Supreme Court, both on the August 8th election and the October 26th one? What do you think this process has ignited in our judicial system?
I do think we've been tested enough, especially in the judiciary. We've seen judges differing, which is very good. We've seen bit of politics in the judiciary, especially the Supreme Court. We've seen them mending fences in this transition where we've seen dissenting judges, at least 2 of them,
yes.
complete with unveiled or veiled attacks on the others in terms of how they conducted themselves. That's on 8th of August. But then we see them consolidating each other in terms of their work, the workmanship and the relationship they have, and give one verdict. I do think this is going to be a shorter decision. Last time we went up to deep into the night. But this time round, I believe, because it is one judgment, then they are going to, well, read it, probably. Of course, the exchange, one reads, then the other reads. Yes. But it's going to be shorter. It's not going to be as controversial as last time. They're learning. I think the transition is very important. I think we've tested the Constitution for ourselves. The judges need to differ because they need to express their opinions as much as possible and not necessarily be bound by the context of leadership. They have to express themselves within the law. But eventually, of course, what's important is justice must be done. Justice must be done. Thank you very much, Judge, for your time. Thank you so much. All right. So we will, of course, keep focusing on the Supreme Court. That session was supposed to begin up anytime from 2 p.m. So we'll be crossing over there and